Hello and welcome back to the No5 Chambers Planning Podcast. In this episode, we are going to be discussing a recent High Court case on neighbourhood plans and what it means for decision makers. I am Hashi Mohammed, a member of No5, and I am joined on this podcast by my colleague, Barrister Tim Jones. We are fortunate to have Tim on this because in addition to being counsel advising on neighbourhood plan matters, he is a neighbourhood planning examiner, trained and approved by the government-approved RICS Neighbourhood Planning Advisory Service. Hello, Tim.
Hello, Hashi. How are you?
Very well, thank you very much. I hope all is well with the quarantine life for you. Where are you at the moment?
Very pleasant, enjoying Cannock Chase.
Fantastic. Now, Tim, the judgment that was handed down was just over 10 days ago by Mrs. Justice Lang, in the matter of Lochailort Investments and Mendip District Council. Before we delve into the details of the judgment, just a couple of points in terms of overview. The first thing is to just note that this was a challenge to the Norton St Philip's neighbourhood plan down in the Mendip district in the southwest, and in particular in relation to one policy pertaining to local green spaces designations. The claimant, a property developer which had purchased a number of the sites around and in Norton St Philip's, had been successful in obtaining an injunction actually to halt the referendum that was due to be held in October last year. Quite an unprecedented act. It had been, the claimant that is, against the designations right from the start. The judicial review challenge was heard in the end of March remotely, one of the first cases that was heard remotely in this COVID era. And Mrs. Justice Lang, in her very characteristically comprehensive matter ways of doing things, had dismissed all three grounds. And I have declared an interest in this. I've been involved in this case for quite some time on behalf of Mendip District Council. Now, Tim, I circulated this around chambers and elsewhere when it first came out, but your reaction to Mrs. Justice Lang's findings?
Well, firstly, I'm confident her finding is right. It doesn't contain any surprises. Quite simply, when you are dealing with neighbourhood plannings, apply the words of the statute without a gloss and don't apply law that applies to differently worded provisions. And what's notable about local green spaces is that they're the one form of designation that government advice specifically says can be included in neighbourhood plans. Neighbourhood plans do include other forms of designation, but there's something of an encouragement, subject to strict requirements on neighbourhood planning bodies, qualifying bodies, to include local green spaces.
Interesting. And in terms of the way in which she had undertaken the testing there, you're absolutely right. It does simply say apply the policies and apply the principles. But there's always this tension that people have, Tim, and I wondered what you thought about it, where it seems as though people do not think that the evidence that's put before an examiner, somebody like you, for example, sitting on a neighbourhood plan examination, is as rigorous as, say, a local plan inspector looking at a local plan. Is that a fair distinction, do you think?
Well, it is a distinction. I think what has to be borne in mind is that neighbourhood plans can be for small communities and they are prepared by amateurs.
Yes.
And so proportionality does come into play. In the case of this particular community, it's a population of fewer than 900 people. One therefore looks to see, is what they've done compliant with the basic conditions, with a certain degree of toleration, particularly bearing in mind that the basic conditions, at least the two critical ones, aren't phrased in absolute terms.
Yes, but even when we look at, though, I mean, I was thinking the other day about whether or not actually even the evidence that's heard at a local plan level is as robust as people claim it to be. Fine, you're absolutely right that in neighbourhood plan situations you have people who are relatively amateurish in the sense of not being overly familiar with the planning principles and the law. But is it even right to suggest that somehow the local plan context is so much more robust that it's incomparable? Because we know that a local planning inspector might sit there for hours and hear from various people, but there isn't anything to suggest that somehow there is a huge amount of gulf between the two. Or do you think that's not right?
No, I don't think there's a gulf between the two. Within the context of local plans, what would in litigation be called an unrepresented party can be very much at a disadvantage. And certainly one of the duties of in my view, of a neighbourhood plan examiner is to make sure that people who have something important to say, significant to say, are able to do so, even if they can't do it in a very legalistic way, or if they don't do it in standard planning terminology.
Yeah, so let's look at what some of the findings of Mrs. Justice Lang in this judgment. I mean, were there any particular? It's a very long judgment. First of all, it's worth saying it's a very comprehensive judgment. It has a contents page for what it's worth, and of course, and it runs to 49 or so pages with 20,000 words. So it is quite a lengthy piece of work by Mrs. Justice Lang, who sort of gallops through the history of the jurisprudence and around neighbourhood plans. But were there any particular parts that caught your eye that you wish to highlight to listeners, Tim?
There are several. And the first thing was a non-contentious matter. But she does point out that counsel for the claimant who was challenging the neighbourhood plan didn't submit that the exceptional circumstances test that applied to extending green belts applied to local green spaces. That's paragraph 33. That goes back to my initial point. Just apply the words of the statute, and when that takes you to policy, look at the words of the statute. Be wary of applying something by analogy, which maybe has a different statutory framework. So she starts saying the exceptional circumstances test for extending the green belt doesn't apply to local green spaces. You apply the words for local green spaces. That's paragraph 33.
Yes, and I thought that was interesting because at the hearing, one of the things that kept on coming back up was the reason why Mr. Ground, Queen's Counsel, was trying to draw that analogy was simply to try and suggest that actually there is an exceptionally high bar to local green spaces in the way that one might find in the context of Greenbelt. And actually you could see that the judge there is saying, well, actually, no, don't try and draw analogies where there are none. Stick to what the policies say. And that presumably is also very, very relevant to your own experiences as an examiner.
It's relevant to my experience and not limited to local green spaces. Frequently, I have submissions made to me which aren't as helpful as they might be because they take decisions or case law on different statutory provisions. They don't explain why it's a fair analogy. And they say very little about the basic conditions or, if applicable, human rights, which is what I really need to know about.
Yes, interesting. So let's now look at a few other passages in the judgment. Should we look at, for example, paragraph 92 and 93? What caught your eye about these passages?
This starts with a well-known provision for development management that decision letters must be read fairly and in good faith and in a straightforward, down-to-earth manner without excessive legalism or criticism, and that inspectors are not writing an examination paper. And what Mrs. Justice Lang made plain is that the same principle applies to an examiner's report. Although, of course, there are differences between a report and an appeal decision. Legal challenges which are legalistic, which seek to pick out fine details, are not likely to get anywhere.
Yes, absolutely. And that's an interesting passage as well, because we know that these principles of not reading these documents in an overly legalistic way have been quite a clearly established principles when we're looking at local plan examination or local plan reports, or even a decision letter by an inspector. But this is Mrs. Justice Lang sort of saying, well, why wouldn't it apply equally in the context of the neighbourhood plan?
I respectfully, wholeheartedly agree. I perhaps would add one other point. On one side within the neighbourhood plan, you have a parish council and you have local residents. It's only chance if those happen to include a lawyer or a planner. It is very important that what an inspector says, as an examining inspector says, as far as possible, is in plain English. They need to understand why recommendations are being made.
Quite. If for nothing else, to ensure that the lay people whose communities are going to be affected actually understand.
Well, exactly. They, unlike a district council, they don't have full-time lawyers. Parish clerks are very seldom qualified lawyers to advise them if there's a point of difficulty. Unlike district councils, they don't have chartered town planners to advise them. They will receive the examiner's report. And in fairness to them, that should be in as plain English as can be achieved without departing from accuracy.
Yes, yes. Okay, so let's then look at another passage that it might be useful to highlight to our listeners. Paragraph 150 is where the judge grapples with competing analysis when it comes to this particular designation. It's worth highlighting to people who haven't had a chance to read the judgment yet that in this case we had both a local plan inspector looking at part 2 of the plan and the examiner at the same time looking at these local green space designations. Now, we know that the tests that of soundness, for example, which apply to local plans, is not the same as the tests of meeting the basic conditions which apply to neighbourhood plans. But here there was a competing difference between an examiner and a local plan inspector who were simultaneously examining and looking at same policies, and in particular local green space policy. And here, this is where the inspector grapples with some of that analysis that caught your interest.
Well, exactly. I mean, the first point is just to say about soundness. Soundness is the test for local plans. Soundness is not the test for neighbourhood plans. That was a deliberate decision by Parliament, effectively, at least to some extent, a less demanding test. The test is the test that arises from the basic conditions and from convention rights. It's not a soundness test. What we have within neighbourhood plans is a tension between localism, giving effect to the views of local people, and meeting the needs for sustainable development. And that's apparent from the basic conditions. But one has to respect the localism as well as the need for sustainable development.
Yes, and that's a tension that's likely to go on for quite some time. But I think that's something that the judge grapples with quite well.
But exactly.
Yes, Tim, if I may then just take you to paragraph 156 of the judgment. It's worth reading this passage for our listeners where the judge says, I agree with the examiner's interpretation of paragraph 100b of the framework. It sets out examples, not an exhaustive list. It follows that other factors, including those in the defendant's background paper, could legitimately be a basis for a finding that a green space was demonstrably special and held a particular local significance. And the conclusion she reached was that the examiner had proper regard to the framework and the planning policy sort of PPG guidance. So what are your reflections on those two parts that I just looked at and what the judge had said in that?
Well, the judge is unquestionably absolutely right. And paragraph 100b actually includes the words, for example. It couldn't be clearer. So the second of the criteria under paragraph 100 for local green spaces is that it is demonstrably special to a local community and holds a particular local significance. And the words that follow are for example, and that clearly doesn't mean that they are the total that comprises what is necessary for significance. So that's unquestionably the case.
That's it. That's it. And then ultimately, really, the heart of the judgment is when we get to paragraph 159, and there are a number of sub bullet points that run to 10 that the learned judge had picked up as effectively saying, I do not accept that the lawfulness of the examiner's report and the defendant's decision have been undermined by what a local plan inspector was doing in another process where other principles apply. I will highlight a few there for the listeners in a moment, but which of those passages in her conclusions and analysis caught your eye, Tim?
Well, the one that I emphasize, because so many people have got it wrong, is subparagraph 6.
Yes.
And she repeats what Mr. Justice Holgate has said on previous occasions, more than once, and that the soundness test for local plans and basic conditions are different. I emphasize this because in my capacity as an examiner, I still get people referring to soundness, referring to decisions on soundness. That simply isn't the test that I'm bound by statute to apply.
Yes, and I think for me, what was interesting about this one was that the passages that are considered by the learned judge at paragraph 159 is the way in which the claimant sought to argue that the overuse of local green space designations was going to have this sterilizing effect of not allowing sustainable development to come forward. And in that context, it could not have been the right way forward for an area that is trying to put forward a plan. And the claimant kept on coming back to the idea that this would not have passed the sound of a day, really, in a local plan context. And therefore, the judge should be taking a different view. And there was a subtle point they made there, and I wondered what your thoughts were on it, Tim. What the claimant did there was they tried to say, okay, fine, we accept that there are two different tests. We accept that one for the local plan and one for the neighborhood plan is completely different. But what we're challenging here is the decision made by the local authority to accept that the basic conditions have been met. That's the decision we're challenging here, because if the local authority had actually paused and reflected, having heard from a local plan inspector and a neighborhood plan examiner, there's no rational way they could have come to the conclusion that these designations ought to stand. And I wondered what your thoughts were on that in terms of moving one step away from the tests that apply in a local plan or a neighborhood plan, but actually the decision that is being made that takes those two into consideration.
Well, the first point is that government advice is clear that local green spaces should be consistent with sustainable development. They should complement investment in sufficient homes. That is in paragraph 99 of the framework. And it is clearly possible for a qualifying body to have so much in the way of local green space that it would impede sustainable development. Whether that is the case is a matter of planning judgment. Firstly, for the examiner producing the report, and then for the local planning authority. So the broad principle is clearly right. You mustn't impede sustainable development, but that doesn't prevent designating local green spaces which are expressly allowed for in policy. It may prevent designating too many. It may prevent designating them in the wrong place.
Quite. Following the judgment and some of the consequential matters that came about was that the claimant sought to appeal, and that appeal was not granted permission by Mrs. Justice Lang at first instance. And they were effectively saying that she had got it wrong by concluding that the basic conditions had been met, and in that the defendant, in performing its function, neither intended nor was required to duplicate the detailed examination of the evidence and the planning merits, which was undertaken by the examiner and summarised in her report, which is what the judge had concluded. And then they go on to challenge the issues and the conclusions that were reached by the judge. It's impossible to know what's going to happen next, but in terms of your reflections as to the prospects of this ever succeeding at appeal, do you have any preliminary thoughts, Tim?
Well, I'm going to be very careful because I wouldn't want to tell the Court of Appeal what to do or appear to tell the Court of Appeal what to do.
Yes.
It does seem to me that a lot of the arguments of the claimant are really inviting courts to go into planning merits. Planning merits are in the first instance for the examiner and then for the local planning authority. In order to persuade the Court of Appeal, first of all, they've got an arguable case. They would have to show there was an arguable error of law. Reading the judgment, I find it, this is Justice Lang's judgment, I find it very persuasive. So I wait with interest to see whether I'm wrong and the Court of Appeal does find there's some arguable point of law.
Yes, I think we will have to wait with bated breath. I think the one critical point that they might be trying to argue for really is the point that you've already highlighted at paragraph 33, in which the claimant seeks to elide that relationship between local green spaces and the question of exceptionality when it comes to greenbelt policy as at the same time. So I think that might be the sort of hook that they will seek to rely upon with a view to gaining permission. But we wait. They are yet to actually lodge their appeal to the Court of Appeal. And finally, the learned judge also gave an order to discharge the unprecedented injunction that they were granted to stop the referendum. And of course, no one knows precisely when a referendum would happen in these circumstances, but we wait to see what happens there as well.
Well, of course, they've always got a right to try and persuade the Court of Appeal that the injunction should be restored.
Correct. Yes.
And leave that to the Court of Appeal.
Yes.
From the perspective of an examiner and trying to see things from the perspective of those producing neighbourhood plans, it seems to me that as far as possible, words should be given their normal, plain English meaning. Of course, some words are technical and they have a certain amount of legal baggage with them. But these are overwhelmingly amateurs. And as far as possible, it's best if one simply sticks to the words of the statutes and the words of guidance and doesn't add glosses to them.
That's very wise and sage advice there, Tim. So thank you very much. That's Tim Jones of No5 Chambers, and I'm Hashi Mohammed. We have been discussing the case of Lochailort Investment Limited and Mendip District Council, the neutral citation being 2020 EWHC 1146 admin. You'll be able to get this from our website when the podcast goes up. Thank you very much for listening to the No5 Chambers Planning Podcast. Have a good afternoon from me.
And thank you from me.